Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. So today we have an interesting little story about the St. Louis City Prosecutor. She's back in the news again. We'll talk more about that in just a moment. So Missouri has this really interesting law called the Sunshine Law. And basically what it says is that if you want information from the government that is in the public record, you can get it. You might have to pay for the copying, but you can get that information. And it lays out the prescription for how you do that. And it lays out the prescription for what happens when a state agency says, no, we don't think we're going to give you that. And the remedy, of course, is to go to court and ask the court to require the agency to deliver the information. So some of you may recall several years ago, right after President Trump was elected, Eric Greitens was elected as governor in the state of Missouri. And like a lot of people who make it to the top, he was a flawed individual. He had an affair with a hairdresser. And there was an allegation, and I would point out there was an allegation only, that he had taken some kind of inappropriate picture of this woman and had used it for some nefarious purpose. I would point out again, there was no evidence that that actually occurred, but that was the allegation. The St. Louis City Prosecutor charged him with an invasion of privacy, took him to criminal court. He wound up resigning, and as things uncovered in the course of that, it was learned that the St. Louis City Prosecutor's Office had crossed a lot of red lines. And as a result, there was an 86-page ethics complaint filed against the city prosecutor. Now, unfortunately, we don't know how that has come out yet or whether it's even been heard, because that kind of stuff is kept secret until such time as the result is announced. So far, there has been nothing that I have seen that talks about that. But I can say that the allegations were pretty serious, and I did do a video on it, and if I can remember to do it, I will link it up here. The bottom line is, the St. Louis City Prosecutor, Kim Gardner, she did not play by the rules in that prosecution. And one of the people who wanted to know why she didn't play by the rules was a reporter by the name of John Solomon. Now, if you watch Fox News, you know who John Solomon is, you know what he does, you know what his political leanings are, and you can assess, rightly or wrongly, where he falls on the scale of being a good guy or a bad guy. But the bottom line is, he used the process that is required to be used to request the records of any communications that Kim Gardner had with George Soros and affiliated organizations. Because apparently what he sought to prove was that this was, again, the use of a cat's paw to obtain a political victory that could not be obtained at the polls. So, what happened? Kim Gardner just blew off the lawsuit, or her agency did. They didn't even file an answer. They just sort of walked into court and said, yeah, Judge, we got some real problems with this lawsuit, and we want to think about it a little bit before we decide whether to file an answer. But unfortunately, that's not the way civil procedure works in Missouri. In Missouri, you have 30 days to answer or otherwise defend. So, you have two options. You can file an answer and say, everything they said is all baloney, right? Or you can file a motion to dismiss, which says, essentially, they don't have a right to get the information that they're seeking. In this case, Gardner's office did neither one. So Solomon and his attorneys filed an amended petition because apparently they didn't ask for enough information the first time. They filed an amended petition and they served it on the office, and the office admitted, yeah, we got a copy of it. And then they had 30 days to answer that petition. The 30 days came and went, and in Missouri, there is a very standard practice of getting what's called a default judgment. Basically, you go into court and say, hey, they didn't even bother to show up. We want a judgment in our favor because they didn't bother to show up. So that's what John Solomon and his attorneys did. They went in and said, we want a default judgment. The judge said, okay. And the state said, well, the state attorney said, wait a minute, hey, hang on a second. We want more time. And they said, you didn't file a motion. You didn't give notice of your intent to seek additional time. So that's denied. And then they said, well, wait a minute. We didn't get notice of their intent to seek a default judgment. And the court said, you're in default. You're not entitled to notice. And that's right in the Missouri Rules of Civil Procedure if they just bothered to read them. So, having blown that, been hit with the default judgment, including attorney's fees, they immediately moved to set aside the default judgment. In order to set aside the default judgment, you have to have a meritorious defense, or at least what appears to be a meritorious defense. It doesn't have to be a absolute defense, but it has to at least challenge the result. And you have to be free of conduct that impedes the judicial process. In other words, it has to be excusable neglect. It was an accident. It was something beyond your control that caused you to miss this. But if you recall, they came into court and said, we think we really need a little extra time to think about this, and we'll get back to you. And that, of course, didn't work. The court denied the motion to set aside the default judgment. Kim Gardner appealed that decision. It went to the Eastern District, and the Eastern District Court of Appeals said, sorry, your default judgment stands. While it's rare, the court here does something that I think probably needed to be done. It points out that there was no merit to the appeal, and they granted the plaintiff's motion for attorney's fees on appeal, and essentially required them to produce all of the records that had been requested to the circuit court so that the circuit court could evaluate any claims of privilege. And you have 30 days to produce all of this information, and you're going to give it to the judge, and then he will assess any claims of privilege that you may or may not have. And as a result, it's a huge loss for Kim Gardner. And heaven only knows what's going to come out of that. We also know that in the past, she did not turn over everything. She didn't turn over everything to Greitens' lawyers. So we really have to expect, at least in some respects, that she won't turn over everything in this. Now, maybe that's unfair of me to say. Maybe she will be completely honest and forthright. But the bottom line is she has a duty to turn over everything, and we have to hope that she will do that because, at least theoretically, lawyers in Missouri have a fidelity to the law, and they do what they're told by the courts. So we have to hope that she will do that. At any rate, it'll be interesting to watch and follow up on. We'll be looking at this, and we will bring to you anything that we learn as this case moves forward. You can find the appellate opinion called Solomon versus Gardner, I think, or Solomon versus the St. Louis City Prosecutor's Office on the Eastern District of Missouri's website, which is available to you from courts.mo.gov. And you can find the little tab that says Pending Cases and Decisions. You click on that, you go to the Eastern District, and you go back to, I think it was the last week in January, and that's where you'll find the opinion. So again, a great place to go and look and see what actually happened, how the court described it, and you'll find it very interesting to read. If you've enjoyed this, I'd really appreciate a thumbs up. And if you haven't already, please go over here and subscribe to our channel. I would really appreciate any comments you have that may bear directly on this. Remember to keep them family friendly. It's oftentimes easy to disparage our political appointments and call names and use profanity. I'd really prefer you not to do that, because there's no point in that. As my mother used to say, profanity is, generally speaking, a lack of vocabulary. Thank you so much for watching. I hope you have a terrific day. I'll catch you.